What are the requirements for a valid ceremonial marriage? A reasonable appearance of authority and at least one party acting in good faith. A valid marriage license is not required, but if there is no license, the marriage must be established by proof. How does a common law marriage arise? To establish a common law marriage, parentheses, informal marriage, it must be shown that the parties agreed to be married, lived together as husband and wife, parentheses, cohabitation, and held themselves out to others that they were married. How can an already established informal marriage be proved? By executing and recording a sworn declaration of informal marriage. It contains an attestation that both parties are 18 or older, neither is already married, and that the applicants are not related within the prohibited degree of consanguinity. What makes a marriage void? Two things. One, consanguinity, that would be marriage of brother, sister, aunt, uncle, niece, or nephew, and includes half-bloods. Two, bigamy, when the other marriage is dissolved, the current marriage becomes valid by operation of law. Children of void marriages are marital children for all purposes. What makes a marriage voidable? 5 things. 1. Underage, if a child is married without consent, a suit may be brought to annul. Marriage is voidable at discretion of the court. 2. Alcohol or narcotics. Permanent impotency, fraud, duress, force, if at the time of the marriage any were present. 3. Mental incapacity, brought by either party. 4. Concealed divorce within 30 days of marriage, if the petitioner did not know and a reasonable person would not have known, must be brought within a year. 5. Marriage less than 72 hours after issuance of license, if brought within 30 days. In all but minor and 72-hour rule, a party cannot annul if they voluntarily cohabitated after the situation was dissolved. Okay, 6. What powers and duties arise from a marriage? The power of capacity is given regardless of age to all who are married. There is a duty of support. Each spouse has a duty to support the other spouse and her minor children. As a result, each spouse is personally liable for contracts for necessaries. What are the grounds for a no-fault divorce and how can it be defended? A no-fault divorce will be granted upon the ground that a marriage has become unsupportable. The only defense is a reasonable expectation of reconciliation. What are the grounds for a fault-based divorce? And there are 6. Adultery, cruel treatment, abandonment for more than a year, living apart for at least 3 years, confinement in a mental hospital for at least 3 years, and conviction of a felony involving at least 1 year imprisonment. The only defense is a denial of grounds. On what grounds can a spouse recover damages in a divorce? A spouse can recover for intentional infliction of emotional distress. In dividing the community estate, fault can be considered, but a spouse cannot recover both a disproportionate share of the estate and tort damages based on the same conduct. There is no independent cause of action in tort for damage to the community estate. What power does the court have to determine if there is a reasonable expectation of reconciliation? A court can order the parties to submit to counseling to determine if there is a reasonable expectation of reconciliation and can order additional counseling for an additional 60 days if the court believes that there is a reasonable expectation of reconciliation. The counselor will submit a report to the court giving her opinion as to the prospects of reconciliation. What are the standing requirements for divorce in Texas? The petitioner needs to have domiciled in Texas for at least 6 months and in the particular county for at least 90 days. A non-resident may petition in the county of appropriate venue for their spouse who meets residency requirements. A court does not need personal jurisdiction over both parties to grant a divorce. What are the requirements for a suit for annulment or to declare a marriage void? These actions may only be maintained if the parties were married in Texas or either party is a domiciliary of Texas. What is required for long-arm jurisdiction over a non-resident spouse? A court has personal jurisdiction over the defendant if Texas is the last marital residence of the spouse and the suit is commenced within 2 years after the date on which marital residence ended or any basis that doesn't offend the state or federal constitution. What is contained in the pleadings for a divorce annulment suit to declare a marriage void? The pleadings contain allegations of the grounds relied on substantially in the language of the statute and must not contain a detailed statement of evidentiary facts. A petition must state whether a protective order for domestic violence is pending or in effect. What must be filed with a dissolution of marriage petition if there are minor children from the marriage? If the parties are parents of a minor child, the action must include a separate suit affecting the parent-child relationship, SAPSR. What restrictions are there on transfers and debts while a divorce is pending? After the petition for divorce, a transfer of community property or the incurrence of a community obligation is void with respect to the other spouse if there is an intent to injure the rights of the other spouse, but is not void with respect to third parties if they have no notice. Notice to third parties can be given by filing a lis pendens. Are jury trials available? Yes, but the findings are only advisory on all issues except child custody. Is there a waiting period for a divorce? Yes, 60 days, but a decree entered in a shorter period is not subject to a collateral attack. Is there any informal procedure for an uncontested divorce? Yes, the parties could agree to use collaborative law procedures or mediation. For collaborative law procedures, the parties and attorneys agree in writing to use their best efforts and make a good faith attempt to resolve their dispute without judicial intervention, except to have the court approve the agreement. The attorneys must agree that if the parties do not settle, the attorneys will withdraw from the case and will not serve as litigation counsel. Status report filed with the court after 180 days and 1 year. After 2 years, the case is dismissed or set for trial. In mediation, the agreement is binding if it so states. Is signed by both parties and their attorneys are if present. A mediated settlement that meets these requirements is entitled to a judgment on the agreement. When can a protective order be issued? A protective order can be granted upon a showing that the other party has committed family or dating violence, which consists of intentional use or threat of physical harm. Venue is county where either applicant or respondent resides. Maximum duration is 2 years, but 1 year after it is ordered, subject can request a determination of whether it is still necessary. Court can order respondent to complete a battering, intervention, and prevention program, counsel with a social worker, or perform acts the court determines are appropriate to prevent or reduce the likelihood of family violence in the future. Notice and hearing is required. When can a temporary protective order be issued? A TPO can be issued ex parte if the court finds clear and present danger that spouse will commit family violence again. A TPO is valid for 20 days, but can be extended for an additional 20 days. A TPO can evict spouse from family home if 1, spouse files a sworn affidavit giving a description of the facts supporting the TPO, and 2, spouse appears in person to testify. In divorce proceedings, what can a TRO be used for? A TRO can be granted ex parte when there are unreasonable acts of the sort that no reasonable person could think he or she could commit, i.e., vulgar telephone calls with intent to annoy and alarm, threats of bodily injury, falsifying records, removing, concealing, transferring property, etc. A TRO cannot be granted for reasonable acts. In divorce proceedings, what can a temporary injunction be used for? After notice and hearing, a court may issue a temporary injunction barring unreasonable acts and reasonable acts that the person could ordinarily do. A temporary injunction can also be used to award one spouse exclusive use of the residence, order payment of temporary support, attorney's fees, require a sworn inventory, or require the production of the books from a family business. What is the presumption of paternity in context of marriage? A man is presumed to be the father of a child if 1, the child is born during the marriage within 300 days after the marriage is terminated, Or 2, the man married the child's mother after the child's birth, and he voluntarily asserted his paternity by filing a record with the Bureau of Vital Statistics, agreed to be named on the child's birth certificate, or promising in a record to support the child as his own. 3, during the first 2 years of the child's life, he resided with the child and represented to others the child was his. How can the presumption of paternity be challenged? Either genetic testing or a written denial of paternity coupled with a written acknowledgement of paternity by another man. Generally, the challenge must be brought within 4 years unless the court finds that the presumed father and mother did not live together or engage in intercourse during the probable time of conception, and the presumed father never openly treated the child as his own. Can a court prevent genetic testing? Yes. This is called paternity by estoppel. The court may issue an order denying genetic testing and adjudicating the presumed father to be the father of the child if the court determines that the conduct of the mother or father stops that party from denying parentage, and it would be inequitable and against the best interest of the child to disprove the father-child relationship. What does a genetic test have to show to establish paternity? The test must establish at least a 99% probability that the man is the father based on a paternity index of at least 100 to 0. What liability does a parent have for the torts of a child? A parent is liable with no dollar limit for property damage caused by a child's negligent conduct if reasonably attributable to negligent failure to exercise parental control or discipline. A parent is liable for willful or malicious conduct of a child aged 12 or older. Liability is limited to $25,000 per act, plus court costs and attorney's fees. A parent is also liable for actual damages up to $5,000, plus court costs and attorney's fees, for any theft committed by the child. How can a third party challenge the presumption of paternity of a child? Third party must file an action within 4 years and submit to genetic testing. How is back child support handled? The court can order the payment of child support retroactive from the child's birth. There is a statutory presumption that retroactive support for the previous 4 years is reasonable and in the child's best interest. Presumption can be rebutted by showing that the man knew or should have known that he was a father and sought to avoid establishment of a support obligation. When may a child be adopted? When both parents have died, the parent-child relationship as to each living parent has been terminated, or in second marriage situation, all adoptions are subject to the best interest test. How is an infant adoption accomplished? A petition to terminate the parent-child relationship is filed. Affidavit of status of child is signed by mother after first trimester. Affidavit of relinquishment of parental rights signed by mother. Affidavit of waiver of interest in child is signed by father. What is an alleged father's rights with respect to a proposed adoption? Alleged father has a right to bring a paternity suit. If he refuses to sign an affidavit, his rights can be involuntarily terminated upon a showing that he didn't respond to the process after being served, failed to file with the paternity registry within 30 days after the child's birth, or by proof of culpable acts that are grounds for termination of parent-child relationship, i.e. abandonment during pregnancy. What grounds are sufficient for an involuntary termination of the parent-child relationship? And there are 8. Abandonment, abuse, neglect, imprisonment for over 2 years, culpable acts toward child or another child, failure to support child for 1 year, use of controlled substance, statutory test, best interest of the child, proof by clear and convincing evidence. What reports must be completed before an adoption can be finalized? A pre-adoption screening, a post-placement adoption report, a report showing adopting parents' criminal history, and SHEG report, SHEG report. That's social, health, education, and genetic history, including any history of abuse suffered by child. What factors does a court consider in the appointment of a managing conservator? Statutory, best interest of child, no discrimination based on gender or marital status, evidence of past domestic violence, evidence of false report of child abuse, the common law, and again, we're looking at the factors. What factors does a court consider in the appointment of a managing conservator? Under the common law, desires of the child, child's physical and emotional needs, parental ability, stability of home environment, parents' plans and opportunities for the child, acts and omissions showing one is less fit than other. Either party can request a jury determination, which is binding on the court. Split custody is allowable, but there is a strong preference to keep children together. When will visitation be denied? Only upon a showing of danger to the child's physical or emotional health. Upon motion, the court can restrict visitation. When can a court allow a joint managing conservatorship? When a court finds it is in the child's best interest, that's a statutory presumption, and the child's physical, emotional, or psychological needs will benefit. Parents have shown an ability to reach shared decisions. Both parents participated in child rearing. What are the major aspects of a joint managing conservatorship? Exclusive power to make certain decisions are given to one joint managing conservatorship, the primary joint managing conservator, JMC for short. JMC does not require equal or nearly equal physical possession of child. The court order must establish the child's residence or designate which JMC has the exclusive right to determine, including provisions to minimize the disruption of child schooling, daily routine, and association with friends, and set out rights and duties to be exercised solely by one JMC and those decisions to be exercised jointly. One party can be ordered to pay child support. How is visitation awarded? Visitation must be a standard possession order unless parties agree otherwise. If parents live within 100 miles, non-custodial parents get one evening per week, every other weekend, and 30 days in the summer. Non-custodial parent must pay for travel expenses related to visitation if they have resources to do so. What is the scope of the child support obligation? Court-ordered child support must terminate upon child reaching 18 or graduating high school, whichever is later. It also terminates upon child's marriage, but not on obligor's death. Obligor parent must be ordered to provide health insurance. What remedies are available for the enforcement of child support? Think MMC triple L. All final orders for child support must provide for M, mandatory withholding. The maximum amount is 50% of take-home pay. If obligor is self-employed, he can be required to post bond. Other remedies include M, money judgment, plus 6%, C, contempt, L, license suspension, child support, L, lien for arrearages, L, levy and execution of financial assets. How can a Texas child support order be enforced outside of Texas? Under the Uniform Interstate Family Support Code, or Act, a party sends 2 copies of the support order, one certified, to the foreign court, together with a sworn statement of the party showing the name and address of the obligor, and if known, the address of the employer. Upon registration, the order becomes an order from that state and will be enforceable by traditional means. A party could also reduce arrearages to judgment, and it will be enforceable under full faith and credit. Party can also mail obligor's employer a copy of the income withholding order. This automatically triggers withholding unless obligor contests the validity of the order. Also, try their Attorney General Child Support Division. What remedies are available to enforce a child custody order? Habeas corpus, tort liability for interference with child custody, and contempt. What does a habeas corpus action entail when used to enforce a custody order? The sole issue will be whether there was a valid court order awarding custody. The other parent cannot counterclaim for reconsideration of custody. Exceptions, whether custody order complied with DP Temporary order can be issued if there is a serious immediate question concerning child's welfare. Court may also consider a cross motion for custody if the child has not been in the relator's possession at any time within the past 6 months. When can a habeas corpus action be brought without a prior court award of custody? When a non-parent is withholding custody of a child. What are the grounds for interference with child custody, and who can it be brought against? Action is available against non-custodial parent who kidnaps the child or withholds it in violation of a visitation order. Can also be brought against third parties who aid and abet, even the attorney. Allows for actual and punitive damages. Must give notice by registered or certified mail of intent to file tort suit in 30 days unless custody order is complied with. Who has jurisdiction over a child custody dispute involving parties from multiple states? Under the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA, the Sapser Court has continuing exclusive jurisdiction as long as at least one party continues to reside in that state. Then the primary test is home state jurisdiction, which is the child's home state or the state in which the child has lived for at least 6 consecutive months. Temporary emergency jurisdiction is then available where a child has been abandoned or abused. The state can take jurisdiction if no other state accepts jurisdiction and there is a significant connection and substantial evidence in the state. How can another state's custody order be enforced in Texas? Under UCCJEA, the order can be registered in Texas and enforced in the same manner as a Texas order. There is also an expedited enforcement in habeas type proceeding. Also, a court can issue a warrant to take immediate possession of a child on a finding that the child is imminently likely to suffer serious physical harm or be removed from the state. How can a child support order be modified? A motion to modify support order is filed in the Sapser Court. The motion must state that circumstances of child or affected party have materially or substantially changed, or that 3 years have elapsed since the order was entered or last modified. And the amount of support differs from the statutory guidelines by either 20% or $100. Parents cannot agree to modify or settle a claim for rearages without court approval. How can a custody order be modified? A motion to modify managing conservator is filed in the Sapser Court. The motion must state that modification would be in best interest of child and that circumstances have materially and substantially changed, or the child is at least 12 and has filed a document with the court indicating who she wants to live with, or the custodial parent has voluntarily relinquished the primary care and possession of the child for at least 6 months. A modification cannot be sought within 1 year of a prior determination absent special circumstances. Can grandparents be given court-ordered visitation? Yes. A grandparent can file a grandparent's petition for reasonable access. Generally, either the child has lived with the grandparent for 6 months or the child's parent is not available. But the grandparent's rights may not be constitutional. U.S. Supreme Court ruled a similar statute unconstitutional. Texas courts are split. What must a professional do if he suspects that a child is being abused? A professional who believes a child has been physically or mentally abused or neglected must report the information within 48 hours. The duty cannot be delegated. The identity of the person making the report is confidential, and a person who in good faith reports the abuse or neglect cannot be liable civilly or criminally. Failure to report is a misdemeanor. What can the state do if they suspect that a child is being abused? The Texas Department of Protective and Regulatory Services, TDPRS, can take possession of a child without a court order upon information that would lead a person of ordinary prudence and caution to believe the child was a victim of child abuse or sexual abuse. An ex parte hearing must be within 3 days and parents must be given notice. To retain the child, the Texas Department of Protective and Regulatory Services must present sufficient evidence to show a continuing danger and a reasonable likelihood that the child will be the victim of abuse in the future. Okay, that's it for the family law bar memorization outline. End.